Hello, everyone. We're going to wait about a minute or two just so people can log on. We'll start at 2 minutes past 2. Just in case you've just joined, we're going to start in a minute or so. Just waiting for everybody to come on. So welcome. If you've joined already, give us a minute or so. Thanks. Hi, if you've just joined, we're going to start in a few seconds. We're just waiting for people to come on. Okay, good afternoon, everyone. Thanks for joining us on this webinar. It's the first time I've done something like this, so forgive me if I'm a bit confused and stuttering through it. What brought us to this is that earlier this year, we won an important ruling at the appeals panel of the Press Council. Last year sometime we published a report on a company that was offering oxygen therapy to people and claiming that it could cure and treat many diseases. And the claims were unsupported by any kind of evidence. And we ran this report. Before running it, we considered whether we needed to go to the company to get their views on what they were doing. And we made a conscious decision not to. And we realized that it could likely result in a Press Council complaint. But we decided that the probability of us winning such a complaint was high and that we believed we'd taken the correct approach. We lost, the Ombudsman ruled against us, but we appealed. And when we appealed, we brought Jacques Louw, our lawyer, on board to help us with the appeal. And thankfully, that made a huge difference. And at the appeal, we won. The case deals with critical issues around reporting, how we report science, and particularly health, but also how do we report climate change. If we write an article that debunks the claims of climate denialists, do we need to give the climate denialists a right of reply to explain what they're doing? Same thing with this. If we say that someone is offering a quack remedy, do we have to give that person an opportunity to explain his remedy? Our view is that we weren't so obligated, and ultimately the Press Council appears to have agreed with us. Jacques is a media lawyer of many decades experience. He's served us very, very well at Ground Up. And without further ado, Jacques, you're on.
Good afternoon. I think I must start off with a warning, and that is that I'm not a good writer, I'm not a good lecturer, and I suppose consequently I am not used to speaking on venues like this. I am also primarily a lawyer, so speaking to journalists always and students always make me slightly nervous. On the odd occasions that I ventured into writing, I've been accused of being very boring when I write, so I trust that I won't be too boring today. For that purpose, I'm going to keep my talk short and hopefully get many questions, because it's usually in the question and answer section of these sessions that I find that we achieve the most. So what are we talking about then today? I've structured as two subjects. The one is science journalism and generally what constitutes science journalism, if there is such a thing. And the second is the meaning of the case of Wiener versus Groundup, or Weiner, which is the case that Nathan referred to during the introduction, and how and whether that develops science journalism at all in specifically South Africa. And I think seeing that this is about an interface between science, journalism, and the law, one can see this, the importance of this subject in the recently reported cases on pseudoscience relating to COVID. Every person and his neighbor talks about cures and analyze data, and very few of these people are scientists, even if they might be medically qualified. They're not necessarily scientists in the subject that they specialize in. Also, scientists aren't always right. Scientists try their best, and they try their best in the subject that they specialize in. I recall I had dinner once with a theoretical physicist who had just finished a PhD thesis on the subject of string theory and the holographic effect at the events horizon of black holes. He got his PhD from the Max Planck Institute, and we had a discussion insofar as I can participate in science discussions of that high-level nature, which is not very far, on this subject of string theory. And at some point during the dinner, after quite a few glasses of wine, I asked him one critical question. I said, can you explain to me what energy is? And it was as if I hit him with a hammer on his forehead. He couldn't answer the question. And after thinking about it for a very, very long time and umming and ahhing, he said, it's a mathematical equation. And I think why I thought of that story when I prepared for today is that the science journalist is the one who spans that bridge between where the theoretical physicist is involved in his complex mathematics and some layperson on the other side needs to be explained the meaning of what the theoretical physicist is talking about. I also thought of another story which I want to use by way of an introduction, and that's something that I read quite a few years ago, and I can't recall all of it. But at one stage during the late 1970s or late 1970s, early 1980s, a discovery was made in Australia by Australian scientists that gastric ulcers are 9 out of 10 times caused by the Helicobacter pylori bacterium. Glaxo Wellcome at that stage was the main pharmaceutical company treating gastric ulcers, and they had what is basically an antacid called Zantac, which grossed for them about $2.5 billion per annum. That's $1 billion. The rest of the world's scientists made the Australian scientists out to be pseudoscientists, and they were, for a period of about 5 to 6 years, they were ridiculed by scientists around the world. It turned out that they were correct, and it happens to turn out that the rest of the world's scientists started supporting their scientific discoveries shortly after the Zantac IP protection expired. I thought about this again when I considered, what is pseudoscience and what is not pseudoscience. And when one gets involved in the business of science, when big business is behind science, I think one needs to take some care. Another example that I want to use before getting into the discussions of the law and journalism is, again, an anecdote. There was a professor at UCT that I consulted when I was involved on the board of a medical scheme, and we consulted him on treatment of oncology, oncological treatment. And he once relayed to me that during the 1950s, I think it was the 50s, cancer specialists were ridiculed when they even came close to alleging that cancer was caused by, could be caused by a virus. I think today everyone accepts, and most scientists accept, that quite a few cancers, especially cervical cancer and so on, have a primary virus cause, although obviously a lot of it is complex and not clearly understood. But again, I thought of that as, there was a long period in the development of cancer research where the scientists who made allegations that cancer could be caused by viruses were regarded as pseudoscientists, and they were ridiculed. So the moral of the story is that really science is what it is on the day that you look at it, a bit like Schrödinger's cat. That brings us back to, how does a journalist deal with science, and how does a journalist deal with pseudoscience? So with that background leading into what Nathan spoke about earlier, to give a timeline to the ground up ombud issue with this pseudoscience question. Ground Up published an article in March 2019. It then got involved in an exchange between a subject that was mentioned in the article, and I'll get to who the subject is, and eventually between the press ombudsman, and a case that should have been settled very quickly was ruled on by the press ombud in November 2019. The press ombud made three findings. Firstly, it made the finding that the Ground Up article was factually correct. So everything that was stated in the article was true. It was also in the public interest. The second finding was, and that was primarily based on some fairly strong arguments made by specifically Nathan, and also by Professor George Claassen of Stellenbosch University, who acted on his own accord because he believed strongly in the subject. That in science reporting, it's not necessary to get the comment from a subject of critical reporting. And it's very interesting and I can't go into to read all the literature that Professor Claassen presented to the press on that subject, but I have copies of it, and eventually it will find its way into something that I might write if I can learn how to write. The third, and this is really the interesting part of the article, was that Ground Up was ordered to apologize to this particular subject of the critical reporting. And the reasoning of the press ombud is not that easy to understand, but she seemed to think that because Ground Up only singled out one company in its example of pseudoscience on a specific issue, the Ground Up should have approached this particular company to ask them for their comment. It's difficult to understand what Ground Up would have published about the comment, because the ombud said that in a first finding that it was not necessary to get comment about the subject matter. So it's not clear what it was going to be that the comment would contribute to the article. So the subject of this particular article was a company called Oxygenate, with the O squared, so that it represents the symbol of oxygen. So I'll refer to it as Oxygenate. Ground Up obviously felt that aggrieved by this ruling and took the ruling on appeal on many grounds. To give an indication, the notice of appeal ran into, I think it was about 90 pages. Eventually, Groundup won the appeal, and the decision was made in March 2020, a year after the publication of the article. So much then for a rapid dispute resolution at the press ombud. The ruling was written by Judge Bernard Ngwepe, who, for the purpose of the appeal, accepted the ombud's ruling that science reporting does not require a comment from a subject. Judge Ngwepe further found that because the subject did not cross-appeal this ruling on science reporting, he had to accept it as part of his ruling. Unfortunately, I think that might leave the question open for someone in future to attack the press ombud's decision. But for the time being, that is the decision that stands. So that, in a nutshell, spans the Press Council case that was concluded a year after the publication of the article. So then, to summarize for today, I will discuss the question of what so-called science reporting is, the law in relating to science reporting, and then the Press Council's rules and how it should relate to science reporting, and the mentioning or criticism of pseudoscience in reporting. I'm going to try and keep this monologue short and hopefully get some good questions that I can answer or try to answer at the end. So I think we all know what science is. Science is knowledge, and it's a knowledge based on a study of the physical and natural world. I think it can go wider than just the physical and natural world. I think psychology could also be a science, which goes more into the esoteric. And I do think science stretches much further than what people normally think of science, like medical science or physics, matters. I think history can even qualify as a science. Mathematics is I mean, every science form of science uses mathematics. The second issue about science is that it's not necessarily correct. I've used these examples of the Helicobacter pylori bacterium, of cancer research. Scientists investigate facts and they publish those facts and base theories on those facts based on the mathematical probabilities of those theories being correct. So scientists always invite criticism, and they invite other scientists to try and prove them wrong. When they write, they submit their material for peer review to other scientists, and they publish when it has been peer reviewed. I also think very few scientific papers necessarily have eureka moments in them. The science usually just theorizes and hopes that his theory is correct, and believes that his theory is correct based on extensive research. So when we think about science, it's what the prevailing scientists at the time would argue. And when you think of what is pseudoscience, it is, I suppose, best exemplified by the current debate between someone like Dr. Fauci on coronavirus in the United States versus all the pseudoscientists that are quoted by Donald Trump from time to time. But I'll leave the politics out of it. Science journalism, as I've said earlier, is very important because it's the bridge of between the scientist and the layperson. with regard to that specific scientist's expertise. I don't think many good science journalists are scientists. I think they are primarily journalists who can write well and who can understand and know how to interpret what the scientists write and know the best way to communicate that to the public at large, those people who don't understand. So what then is pseudoscience? Pseudoscience is what the predominance of scientists don't agree with, I would suppose. And what are examples of pseudoscience? I mean, quite clearly, we now know more than just the theory that the Earth is round. So if people are flat Earth supporters, and I hope I'm not speaking to any, then quite clearly it's wrong, and that would be pseudoscience. We know from the past history of in South Africa that when all the science regarding to HIV and AIDS became well known, it was pseudoscience to deny that AIDS was a virus and that it was a problem that killed many people when they got it. So the question then, and this is really what we are talking about today, is does science reporting need a special pigeonhole that it can slot into? And I think, let me then explain what the Ground-Up article was about that became the subject of the Ombud ruling, because I think it's a very good example of good science reporting versus pseudoscience, and good science reporting that mentions pseudoscience. The article was written by Natasha Bolognesi, who's a specialist science journalist and holds 3 degrees, 2 in language and 1 a master's degree in journalism from the University of Stellenbosch. Other degrees are from UCT. She's a highly acclaimed science journalist, and she's written many top articles on the subject of science. The article covered the topic of hyperbaric oxygen therapy, which goes under the acronym HBOT. And HBOT is what we know as these massive tanks that are on diving boats where divers get put into when they suffer the bends. It's a machine that puts oxygen into their bloods, into their blood systems. The article carried opinions of 3 top scientists on the subject of HBOT in the country. The one is the president of the South African Underwater Hyperbaric Medical Association, a medical doctor with a string of degrees that would cover half a page. The other expert that was consulted by Bolognesi was Dr. Jack Meintjes, who's the program coordinator of the Underwater and Hyperbaric Medicine program at the University of Stellenbosch and a medical specialist. Again, I'm not going to go into all these degrees, but they're impressive. The last person she consulted was Dr. Gregory Weir, who runs a vascular and hyperbaric unit in Pretoria. He's a registered and practicing vascular surgeon, and again holds many certificates that would cover many walls. All 3 doctors are clearly the top specialists in this particular aspect of science. One of the things that the article covered was what's called so-called mild hyperbaric oxygen therapy. It's, shall we say, the DIY version of HBOT, and it goes under the acronym MHBOT. And this is where Oxygenate comes in, because in researching the article, and there was a reason why Bolognesi wanted to publish this article, because it was very necessary for a number of people, a number of reasons that I will get to later. but in the article, it mentions the so-called quackery that goes with MHBot. And in getting to this quackery, the company Oxygenate was mentioned. And I'm going to read the entire quote from the article where Oxygenate is mentioned in the article. It goes as follows. The South African company Oxygenate claims MHBot can be used for a string of indications, including cancer, stroke, Parkinson's disease, Alzheimer's disease, autism, arthritis, multiple sclerosis, and cerebral palsy. In fact, if you go into the MHBot, into the Oxygenate website, you will see that there are 24 different conditions, varying conditions that they offer treatment for. I carry on with the quote. Oxygenate also advertises its services for diabetic ulcers and burns, conditions indicated as treatable by HBot only. Treatment costs range from 500 Rand an hour to 8,000 Rand for 20 treatments. The company also sells soft hyperbaric chambers for home use. Then lastly, where Oxygenate is mentioned, it's the following quote. The company, Special Kids, advertises mild hyperbaric treatment through Oxygenate for off-label conditions in children. Its website provides a direct link to the Oxygenate website. And again, this is where parents who have children with autism get lured into getting Oxygenate treatments from these websites. With regard to these quotes, Dr. Mankies, and I remind you, she's the chairman of the association that deals with HBot. She said, our colleagues associate us with this quackery, and they don't refer patients to us here at Tygerberg HBot department. Instead, despite the evidence for successful treatment of soft tissue and bone damage following radiation or certain diabetic foot wounds with HBot, 2 or 3 amputations are done each day at Tygerberg Hospital. We do not get a single referral, and it costs the state patients nothing to be treated here. So this is where the importance of distinguishing between MHBot and HBot comes in, and why it was important for Groundup to publish this article. So obviously, Oxygenate is damaged by this quote. The quote is defamatory of them because it says that their claims amount to quackery. But I'll get back to how the law looks at this specific type of defamation. So let's look at Oxygenate. It's a company with 3 directors. The one's a lawyer who got his degree from University of Bogota. The other one is a biokineticist. He holds a BSc degree, so I suppose he's got some science training. And the last director is an accountant. It seems that the biokineticist is the one who really runs the whole HBot scheme of this company. When Groundup Googled the URL of Oxygenate at the time of preparing this article, it was the first and the main one that popped up on hyperbaric oxygen treatment of all the non-academic links that popped up on Google. So it's widely advertised, and it's out there. It's in your face on the internet. They also advertise online bookings, and they advertise credit facility. And quite clearly, it's a money-making institution, making all these huge scientific claims about the benefits of their treatment on the website. It's quite clearly, from a Google search, the most prominent MHBot supplier in the country. So if one analyzes the article, it's quite clear that it didn't contain any news. It was an article of the opinions provided by 3 top people in their field with expertise. It was an article where the scientists warned the public against non-medical use of MHBOT treatment. It warned the public that it cannot really be used for treatment of Alzheimer's, cancers, and all these other false claims. It warned the public not to confuse MHBOT with HBOT. And when I say public, I mean, as Dr. Manki's indicated, it seems that even the referring doctors get confused by this because they don't refer their patients to the correct treatment and the scientific treatment. And it clearly showed that Oxygenate's claims published on their website are examples of scientific ills. So that's a summary of the article, and I think why the editors decided they had to publish and why they decided not to contact Oxygenate. I may also add that everything quoted from the Oxygenate website was quoted accurately. So, and I won't go into too much detail, but to an extent, Oxygenate did get their right of reply because they actually were quoted from their published website. So having covered the article, what does the law say about science journalism? There's a short answer to this. The law does not recognize science journalism as an independent concept. And what I mean by that is that it does not give science journalists any special privilege over any other form of journalism. The law does deal with certain forms of journalism differently to others. For example, financial journalism has a very special place in the South African legal system, but it doesn't receive any special treatment. Neither in the law does science journalism receive any specific special privilege or treatment. So then the question is, what does the Ombud say? The press code has no exception for science journalism or science journalism privilege. It is silent on the concept of science journalism. In the Oxygenate case, ground up, and as I mentioned, Professor George Claassen also needs to take some credit for presenting arguments on his own. He joined as an interested party in the case. Argued that science journalism holds a different place in the profession. That's a journalism argument. They said that in general terms, it is entirely unhelpful to give to give a right to alternative views on scientific fact. Things like climate change, things like MMR vaccination, evolution. Once the science has been settled and there are alternative views, their argument was you don't have to obtain comment from those presenting alternative views. The Ombud found that, and I'm going to quote her because it's important, because of the arguments about science. So these are the arguments that Professor Claassen and Nathan Geffen presented. It was not necessary to give Oxygen a right of reply. And that, I suppose, is the crux of the question we're discussing this afternoon. So on appeal, as I mentioned earlier, the appeals panel accepted for the appeal's sake that there wasn't a required right of reply when this article qualified as science reporting. So it gives some form of privilege, at least before the Ombudsman, on science journalism. As I mentioned, it's a tenuous privilege because the chairman of the appeals panel said he's not going to consider the question further, but he left it open and he said he wasn't going to consider it because there wasn't a cross appeal. So the question then is, where does it leave science reporting? And I think if one looks at what would Groundup have done if Oxygenate had taken them to court? And I think Oxygenate knew they couldn't take them to court because they did threaten in the beginning, but they knew they couldn't take them to court because they would have lost. And Groundup would have had 3 firm defenses against the claim, and they would have won on each one of those defenses. The first was that the article was true and in the public interest. It's the most common defense and the most valuable defense that a journalist can have. But everything in the article, as the press ombudsman, the press ombud correctly found, was true and correct. I see I'm going much longer than my 20 minutes that I promised. The second was that the article was opinion, and opinion only needs to be legally fair in order to qualify as a perfect defense. Legal fairness means that it's based on fact and that the person expressing the opinion believed the opinion was correct or was reasonably held. And the last defense that everyone pleads now is that the article was reasonable. And again, it would be based on the fact that it's reasonable to believe scientists of that stature and to believe them when they are critical of matters that are published and published out there, the so-called Boghoshi defense. So, although I said that the law doesn't recognize a science privilege, the law does give a specific privilege to science journalists in that they are merely, as I said, the breach to the public, and all they can do to be protected against claims is to rely on the scientists, and when it's reasonable to rely on those scientists, as long as they reflect it accurately, they have some form of privilege in the form of reasonable journalism. So, getting back to the one critical issue that was troubling the press ombud, and that was in Rule 1.8 of the Press Code. It says that the media must seek, if practicable, the views of the subject of critical reporting in advance of publication. And it's on this point that I think the Ombud got into some muddled water. Simply speaking, it can't be practicable for a journalist to go and seek a comment from someone who's already published a view that has been completely destroyed by the 3 top scientists on a specific subject in the country. What was that comment going to contribute to an article? Rule 1.8 is a requirement of reasonable journalism, and it's the requirement of audi altrum partem. But like any basic right, there's always an exception to it. And although audi is a very important principle in law, and I would suggest in journalism, when it comes to something like science journalism, there are very many other reasons to justify reasonable journalism. And these, to quote the judge from the Boghoshi case, would be testing the reliability of sources, the need not to publish before establishing the truth in a positive manner. I think Bolognese in her article and Groundup publishing it came through on those 2 grounds with flying colors, and therefore it was not practicable to contact Oxygenate in this particular instance. Rule 1.8 is a qualified rule. Over the about 40 years that I've been advising the media on publishing, I've often advised them not to get someone's comment because of the fear of being brought to court on an urgent application. And that's a risk that the journalist took which would, if you apply Rule 1.8 strictly, would have fallen foul of it because you didn't approach the person for comment. But when you know the facts are true, when you don't have to question the reliability of your source or the need to publish or that it's true, my submission has always been that it's not necessary to approach the party mentioned. It's not a rule that you depart from easily, but I would submit that in science reporting, it's a rule that you can depart from. So I'll wind up. In conclusion, there's no special exception in either the law or the press code for science journalism, but science journalism does have a specialist privilege that is based on the facts of a particular article. It's not always going to be to apply. If one applies the rule of law to reporting of science as contained in the Oxygenate article, there cannot be a requirement for a science journalist to obtain comment when that particular person is criticized by a scientist. And lastly, I would strongly suggest at some point that the press ombud looks carefully at Rule 1.8, either the interpretation of it or how the rule is structured, because it is just too easily applied by the press ombud in the current situation. So that is what I have to say. I apologize for exceeding my time by doubling it, but any questions?
Hi, Jacques. I'm going to proceed by asking you a couple of questions first. So just to summarize, my understanding of what you said and what the judgment, what the ruling is that we publish a report. It's accurate. The ombudsman finds that it's accurate. It quotes Oxygenate accurately. So they're in the article for that reason. And then 3 scientists debunk what Oxygenate is saying. And the ombudsman finds that we should have still gone to Oxygenate for a comment. But the article is accurate. Then it goes on appeal, and Oxygenate do not appeal the finding that either the article is accurate or that it was science reporting. The appeal panel rules that the article that because it's not a news report, it's a science report. It's clearly labeled as a science report. Because it's not a news report, we were not obligated to follow Rule 1.8, which deals with the right of reply of people who are the subject of critical reportage. It's in the same way that an opinion piece, if I go and write an opinion piece saying that you're a very nasty person, I'm allowed to do that. I don't have to come and get your opinion and put it into my opinion piece in order to write that. So on that basis, the press council found in our favor. It's not specifically because it's science reporting, it's because it's not news reporting. And science reporting isn't news reporting, if I'm not mistaken, if that's the correct interpretation. So my question is, what stops someone from labeling an article as opinion, or labeling it as science, or a book review, or whatever, something that isn't news, and then inside it's saying Joe Bloggs pulls the wings off butterflies, and you don't go and get Joe Bloggs' view on whether he actually does pull the wings off butterflies. What am I missing here that would make that different to what we did?
Because saying Joe Bloggs pulls the wings of butterflies is not science. It's an allegation of fact. So you can't, by putting a label at the top of an article, masquerade it as a science report. Also, even if you have a science report and you make factual claims that are not correct, remember that the fairness of an opinion must be based on fact. If it's not based on fact, it's not correct. If I can use the absurd example, if you publish an article that the ice cream sold by a certain shop tastes bad, but you've never tasted that ice cream, you can't express an opinion on it. So that wouldn't be an opinion that's based on fact. If you say that Joe Bloggs is cruel to animals because he pulls the wings of butterflies, and it's not factually correct, that's not a scientific statement, and it's not that's not an opinion based on fact. So it simply wouldn't pass as a fair comment.
And a second question for you is, a proposal was made by Professor Claassen, in fact, and that was in between, if I'm not mistaken, in between the ruling from the Ombudsman and the Press Council Appeal Panel. A proposal was made to change the press code to explicitly state that comment need not be sought from quacks and pseudoscientists, etc., in scientific reporting. In light of this ruling, do you still think that Professor Claassen's proposed amendment is necessary, or is it covered sufficiently by their ruling?
I don't think it's necessary, and I don't think it's necessary for a number of reasons. The one is, as soon as you start legislating exceptions, you are going to run into so many legislated exceptions that the press code is going to become impossible to interpret. The second problem I have with an exceptionalism rule like that is there's still a factual inquiry required of what is quackery, what is pseudoscience, and that can not only be established by it's not automatic. So you're still going to be able to have a hearing, and then the hearing is going to be, is it pseudoscience, is it not? Quite clearly, when an expert expresses an opinion on whether it's pseudoscience or not, that should be the end of it. You shouldn't have to prove it. If you put an exceptionalism rule in, a privilege rule, you are going to open the door for people to prove that try to prove that they're not pseudoscientists, and you don't want to do that. And then lastly, as you correctly say, we now have the Ombuds ruling on it, that when it's proper science journalism, reporting on quackery, you don't have to get the person's comment. So that rule is definitely not required. Did I answer your question?
I think so. And then Marcus Lowe, who's the editor of Spotlight, has sent two questions. And he says, outside of science journalism, is there an obligation on journalists to provide right of reply to people who make demonstrably false claims or wrong claims?
Well, it's a good question. I go back to when I said I've often advised people not to get a right of reply. Obviously, if you look at the various tests, and there's not a closed list of tests that Bogorsi says what would constitute reasonable journalism. But if quite clearly it's a lie, you don't have to go to the source. If the statement was made in a court of law, you don't have to go to the source to verify it. If the person has published it and another person with far more credibility makes a statement, you don't have to go to the source. If you know for a fact that it's rubbish, and you know you'll be able to prove it afterwards, I cannot see why you should go to give the person an opportunity to respond. Obviously, if you don't give them the opportunity to respond and you're wrong, you then published at your peril, and you'll have to face the consequences. But to elevate the duty to get comment, to say that you always have to get comment, I think that's taking it too far.
Right. So Marcus asks a follow-up question. He says, following from that, if the law or press code is to be developed in this area, should it not focus on the validity of the claim rather than the type of journalism? So
absolutely.
Okay.
Absolutely. Yeah.
And then Marcus wants to ask a third question, and there's someone else who also wants to ask a question after that, which I'll come to. He says, can you say more about the distinction between science and news reporting, if there is such a distinction?
Science reporting is primarily the reporting of opinions expressed by scientists. There will be science reporting that could qualify as news, where discovery is made. But if a discovery is made, you're hardly going to get critical reportage. There's not going to be a victim, so to speak. You're going to report on the discovery. That is science. That is, I suppose, science reporting that is not opinion. But the way I see science reporting, and specifically your article in this particular instance, it's a reporting on the opinions expressed by scientists, and as I said, to bridge that gap between the science and the scientist and the layperson, and to explain to the layperson why it's important to know these facts.
Can I just take it a step further and say it was the opinion? It was an article about the opinion expressed by scientists in response to the opinion expressed by a company making claims that were not accurate. So it was an opinion responding to an opinion. I think we would have been in trouble had we misrepresented what Oxygenate was saying. So if we'd gone onto their website and we'd misquoted them, we would have been in serious trouble. And then they would have had a claim against us, perhaps even a defamation claim. But we didn't. We accurately interpreted what was on their website. Yeah.
Can I venture into something again close to home, and I do it very cautiously, but and I'm doing this very cautiously. But in a Nathan, you know what I'm talking about. In a recent radio broadcast, Professor Tim Noakes made certain claims regarding coronavirus, which have been debunked by all the scientists across the world. Although he is a good scientist in certain respects, in this particular instance, he made a claim on something that I think we both believe that he didn't have the necessary expertise to make the claim. A critical article was published only about what he said and the dangers of what he said and misunderstanding it. And in that case, you didn't have to approach him for comment because he was criticized for something a statement that he made publicly. Again, if we were wrong, we would have been wrong not going to him for comment, but we weren't wrong. And he subsequently apologized.
Right. Then we've got another question from Sibusiso Biela. Sorry, I've kept you waiting, Sibusiso. Your question's a little bit off topic, but it's actually interesting nevertheless, and worth trying to answer. Maybe, Jacques, you probably won't be able to answer it without more information, but it is an interesting one, and it's one that many reporters have at one time or another experienced. You're doing a story, and in this case, it's a video of where Sibusiso interviewed a scientist. And at the last minute, the person says they want to withdraw their comment and the story is ready to go. What legal standing does the reporter have in this case?
Sibusiso, it's a very interesting question, and it's not novel. There's actually case law on something very similar. In the case of National Media versus USTA, there was an agreement between National Media and USTA that National Media would be able to publish an article about her and her son and the difficulty she had with the son's father, who happened to be a very well-known rugby player called Naas Botha. It was his illegitimate son. And after three versions of the article was presented to USTA, she withdrew her consent to publish. And because it was about a minor and because private issues, she regarded it as having the right to withdraw her consent to publish. The press went ahead. I think it was De Burger or Rapport, to one of these newspapers, and published, and they got sued. Went all the way to the Supreme Court of Appeal, and I think it was Judge Hurrams made some very, very harsh comments about the media in that case. And he said a person who agrees to speak to the press always has the right to withdraw his consent. So if we're actually outside the realm of the law of defamation here, and is your interview is like a contract with the person who agrees to speak to you. And when you then publish, and you publish information that could be damaging to that person, then that person would be able to claim from you.
Thanks, Jacques. Another question from my colleague at Stellenbosch University, Vida Fourie-Basson. How fair or reliable is it to base your reporting on information from a company's website?
Vida, if the question is, I'm not sure what you mean by reliable. If the question is that, can you assume that that is what the person is saying? If it's that person's website, obviously that is what that person is saying. So when you mean reliable or fair, that's what they put out there. It's what they said. If they didn't say that, why would it appear on their website? I'm not sure I answered your question. Perhaps if you could clarify. Nathan?
Perhaps I could come. Yeah, I'm going to come in. Yeah, I'll wait for Vida to respond further. But what I would say is, in this case, we were quoting the opinion of the company that they'd put on their website. If the company had, if we had gone to their website and said, and quote them and say, therefore it's true what they're saying, then absolutely we'd have a problem, right? Because what they were saying wasn't true. But we quoted them specifically to analyze whether what they were saying was true or not. And yes, in other words, we were quoting their published comment and then critiquing it. And I think it's a definitely fair game to be able to go to a public website and to do that. Anyone who makes a comment on Twitter, on Facebook, on their website is engaging in the public sphere, and their comment must be open to being critiqued. It doesn't matter whether they're not a public figure themselves. If you comment in a public sphere, you can expect to be critiqued.
Quite correct. I mean, if you criticize what people say, and as long as you quote them accurately, if they've and this is what people don't realize: when you write something on Facebook, you publish it, and you open yourself up for criticism. What Oxygenate here did was, and this is not only publish. I mean, that is their advertising material, and you are entitled to criticize it.
I just want to say thanks. James asked a question about Tim Noakes, which you've actually preempted and answered, Jacques. There's one other critique that's arisen, which I want to address. Someone, quite a leading reporter, didn't agree with our approach to this case and criticized us for saying that we should have got the view of the quack, and that we were infringing on freedom of speech by not doing so. I just want to emphasize that in actual fact, quite the opposite. What this case was about was allowing us to have the freedom of expression to not seek a view that we didn't think was useful to seek. Nothing in this case stops any other reporter from having gone to Oxygenate and got their view if they so wanted to. That wouldn't be in breach of the press code. So all we wanted was more liberty, more freedom to do something in a different way that wasn't usually done in the media from this ruling, and that we've got. So I think actually this case extends freedom of expression for journalists a little bit.
Excuse me, can I close off commenting on that? Because every imposition on freedom of expression. Every rule that prohibits publication is an imposition on freedom of expression. The question is it justified? And the right to comment has got nothing to do with freedom of expression. It's a right of audi altram partem, which is a right accorded in opposition to freedom of expression. It's not a freedom of expression issue.
Right. Then one more question. Colleen, asking on behalf of another reporter, says, Jacques said earlier that science journalists don't necessarily have to have a background in science because they serve as the bridge between lay people and theoretical science. As a journalist, where do we go to start verifying what the science industry is saying about a particular topic, or make sure that what we're investigating is credible? Jacques, if you don't mind, I wouldn't mind taking a stab at answering that, and you're welcome to come in afterwards. I mean, it is an extremely hard question to answer. It's a hard question to answer for the reporter on any story that they go to. What are the credible? Who is a credible scientist? Who is worth speaking to? And it requires a fair amount of experience and a bit of training as well. There's no ways we can answer that question properly on this webinar, but I think it is something that Senscom in future should probably look into, and that is if you're a reporter who's not experienced in science journalism, where do you start? How do you know who are the scientists who are credible, who are saying things that are worth reporting, versus the ones who are not quite there? Yeah, Jacques, if you want to...
I'd like to support you there. The best finance journalists that I've come across do not have a background in financial education. They're wordsmiths. I was told by one of the top wine writers once that he's a wordsmith. He's not a wine. He's not knowledgeable about wine. He gained some knowledge that he learned from other people over the years, but he gets his information from experts. I think Nathan touched on it, but the reporter's duty is to go and research who are the best scientists and what is the prevailing scientific view, and interview those people and interpret what they say. Scientists are not good writers. It's like me, I'm not a good writer, but if you can, insofar as I might be an expert, you can get a legal opinion from me and you can write about
it. Jacques, thank you very much. Thanks very much to all the people who tuned in and asked questions, and especially to those who asked questions. Much appreciated. Yeah, it was fun, and I hope we can do some more of these in the future. Thank you.
Thank you. Thanks.